Hi guys, and welcome to another episode of Atty. Javier's Law Lectures for Students. And today we're at the tail end of our discussion on the law of cooperatives. To review, we've already discussed the definition, nature, attributes, powers, responsibilities, and the incidents in the life of cooperatives, as well as how to form and how to dissolve and wind up cooperatives. Today, we'll take up the cooperative principles and the rules of membership. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. A like on this or any of my other videos would also be greatly appreciated. Now let's begin. So to kick things off, we begin with a question: what is a cooperative made of? In general, a cooperative may be said to be composed of two components, namely the members and the individuals who are responsible for the administration of the affairs of the cooperative, namely the directors and officers. Due to time constraints and to better provide focus, we will confine our discussion today to the component of membership, with the discussion on administration having its own separate episode. So, let's begin with the cooperative principles, which serve as a guide on how a cooperative is intended to be run. The law in Article 4 of the Cooperative Code as amended gives us the general directive that every cooperative shall conduct its affairs in accordance with Filipino culture, good values and experience, and the universally accepted principles of cooperation. And what are these universally accepted principles? They include, but are not limited to, first, voluntary and open membership. Cooperatives are intended to be voluntary organizations, so they should be open to all persons who are able to use their services and willing to accept the responsibilities of membership without gender, social, racial, cultural, political, or religious discrimination. Second, we have democratic member control. Cooperatives are democratic organizations that are controlled by their members who actively participate in settling their policies and making decisions. As such, the men and women serving as elected representatives, directors, or officers are accountable to the members. Take note that in primary cooperatives, members have equal voting rights of one member, one vote. Nevertheless, cooperatives at other levels are organized in the same democratic manner. The third cooperative principle is member economic participation, wherein members should contribute equitably to and democratically control the capital of their cooperatives, at least part of which should be the common property of the cooperative. This principle carries at least two responsibilities, namely that members shall receive limited compensation or limited interest, if any, on capital subscribed and paid as a condition of membership, and members should allocate surpluses for any or all of the following purposes, namely developing the cooperative by setting up reserves, part of which should at least be indivisible, benefiting members in proportion to their patronage of the cooperative's business, and supporting other activities approved by the membership. Fourth, we have the principle of autonomy and independence. We know from episode 1 that cooperatives are autonomous, self-help organizations controlled by their members. Thus, if a cooperative is to enter into agreements with other organizations, including the government or raise capital from external sources, they should do so on terms that will ensure democratic control of their members and maintain their cooperative autonomy. Fifth principle is education, training, and information, which mandates that cooperatives shall provide education and training for their members, elected and appointed representatives, managers, and employees, so that they can contribute effectively and efficiently to the development of their cooperatives. Sixth, we have the principle of cooperation among cooperatives, where cooperatives serve their members most effectively and strengthen the cooperative movement by working together through local, national, regional, and international structures. And the final cooperative principle is concern for community, where cooperatives are mandated to work for the sustainable development of their communities through policies approved by their members. Now we can go to the heart of the cooperative, which would be the members. And we can begin with the question, who can be members of the cooperative? Well, we have already discussed this partially in previous episodes, and the answer will depend on the category of the cooperative. Remember, cooperatives come in three categories, no? The primary cooperatives, whose members are natural persons; secondary cooperatives, whose members are primary cooperatives; and the tertiary cooperatives, whose members are secondary cooperatives. For primary cooperatives, they may have two kinds of members, namely the regular and the associate members. As previously discussed in episode 2, a regular member is one who has complied with all the membership requirements and is therefore entitled to all the rights and privileges of membership. An associate member is one who has no right to vote nor right to be voted upon. He is only entitled to such rights and privileges as the bylaws may provide, such as preference in the payment of interest as stated in the bylaws, and priority in the distribution of preferred share capital in case of liquidation, among others. Now, an associate shall be considered a regular member, if they complete the following. Namely, they first meet the minimum requirements of regular membership. Second, continue to patronize the cooperative for 2 years. And third, they signify their intention to remain a member. So how does one become a member? Well, of course, each cooperative may provide for its own rules for qualification for membership, but the law provides for certain minimum requirements, some of which we have already discussed in episode 2 on forming a cooperative. Specifically, for primary cooperatives, members must be natural persons who are Filipino citizens, of legal age, have a common bond of interest, and are actually residing or working in the intended area of operation. To these, Article 28 adds the requirement of making such payments to the cooperative in relation to either membership or acquired interest in the cooperative, as may be prescribed in the bylaws. So to review, only natural persons or actual people can form cooperatives or become members in primary cooperatives. Juridical persons like partnerships or corporations cannot join cooperatives as members in primary cooperatives. Okay? And these natural persons must be Filipino citizens. The law also requires an applicant for membership to be of legal age. So does this mean minors are prohibited from forming cooperatives? No, as discussed in episode 2, the law allows minors to form a cooperative called a laboratory cooperative, which must be affiliated with a registered cooperative called the guardian cooperative, whose duty is to supervise, monitor, act for, in behalf of the only one laboratory cooperative. Okay? The guardian cooperative exercising parental authority may be held liable for any violations in the operation of the laboratory cooperative. Okay? Now, this laboratory cooperative can be formed as a training ground to prepare its members who are minors to join a regular cooperative and to instill in them cooperative values and principles, as well as to teach them the values of thrift and savings mobilization, among others. Membership in this laboratory cooperative shall be terminated when a member reaches the age of majority or 18 years of age, or for any of the grounds for termination of membership, which I will be discussing later on, such as withdrawal, death, insanity, or vote by the majority of directors for grounds provided by law. Okay? And upon termination of the membership in the laboratory cooperative, the former member will be entitled to a refund of his share capital contribution and all other interests in the laboratory cooperative. He may also opt or choose to join the guardian cooperative upon complying with all the requirements for membership. Next, to be a member, the law also requires a common bond of interest, which simply refers to the condition where members associate themselves to attain their common goals and objectives, which may be residential, occupational, associational, or institutional. So, the members may either live in the same place, have the same work or occupation, or belong to the same association or institution. But you can only choose one of those four bonds. Finally, to be a member, they must actually reside or work in the intended area of operation. Now, after having complied with all the conditions for application of membership, including payment, the application will now be submitted to the board. If the board of directors approves the application for membership, then the applicant shall be deemed a member and will be entitled to exercise all the rights pertaining to a member of the cooperative. But in case the membership is refused or denied by the board, the applicant may still appeal, where to the General Assembly, or if it has one, to the Appeal and Grievance Committee, whose decision on the appeal will be final. The appeal has to be decided within 30 days from receipt, failing which the appeal will be deemed approved in favor of the applicant, meaning he will become a member. As for membership in secondary and tertiary cooperatives, recall that their members are not natural persons. Specifically, for secondary cooperatives who want to form a federation, the minimum number of members is 10 primary cooperatives. But if they want to form a union, the minimum number of members is 15 primary cooperatives. For tertiary cooperatives who want to form a federation, the minimum number of members is 10 secondary cooperatives, but if they want to form a union, the minimum number of members is 15 secondary cooperatives. Now let's talk about the rights of members. Now, this discussion on the rights is not meant to be an exhaustive nor all-encompassing lecture on all the rights of the members, because the law and the cooperative itself may provide for additional rights, provided of course they are not contrary to law or public policy. Nevertheless, the code provides for the basic rights of members, one of which is the right of ownership over the shares or interest in the cooperative which the member has paid for. Related to this is the right of a member to be issued a share certificate upon full payment of their shares. The rules on issuance of the share certificate will be promulgated by the cooperative. Now, I discussed shares and share capital in episode 2, but to review, a share refers to a unit of capital in a primary cooperative which has a corresponding value called the par value, which may be fixed at any figure not more than 1,000 pesos, and once fixed, cannot be increased nor decreased through amendment of the articles or bylaws. Also remember, a member cannot own nor hold more than 10% of the share capital of the cooperative. Now, the share certificate is the evidence of the share or interest of the member in the cooperative, which has to be fully paid for. For the discussion on shares and capitalization, you may watch or rewatch episode 2 of this series. Now, the member has the right to transfer his shares or interest in the cooperative, but subject to the conditions set in the bylaws as well as those set in Article 74 of the Cooperative Code. Namely, first, he has held such share capital contribution or interest for not less than 1 year. Second, the assignment is made either to the cooperative or to a member of the cooperative or to a person who falls within the field of membership of the cooperative, and the board of directors must have approved the assignment or transfer. As an incident of the right of ownership of the shares or interest in the cooperative, the member may indirectly enjoy the privileges granted by law to cooperatives as may be applicable. I say indirectly because as worded in the law, it is the cooperatives that are given the privileges, not the individual members directly. And remember that the cooperative has a personality separate and distinct from the members. But of course, the use of the privileges by the cooperative will necessarily be performed and thus enjoyed by the members. Now, I have discussed the privileges of cooperatives in episode 1, so I won't go over them one by one here. But some privileges which a cooperative has that can be enjoyed by the members include preferential rights to supply their agricultural products to government agencies, and preferential treatment in the allocation of fertilizers, seeds, and agricultural input from government agencies, among others. Now you may review the privileges of cooperatives in the discussion in episode 1, or you can also view the full list of privileges in Article 62 of the Cooperative Code as amended. Now, another privilege and right which members enjoy involves the benefits under the Patronage Refund, which has been discussed previously in episode 5. To review, the Patronage Refund is a principle of equity which establishes an equal right of members to participate in the organization and to equitably share in the benefits accruing thereto. Under this principle, the net surplus of the cooperative, which is not construed as profit, will be deemed to have been returned to the members if it is distributed in the following order. First, to the reserve fund. Second, to the education and training fund. Third, to the community development fund. And if the cooperative has chosen to create them, then fourth, to the optional funds for cooperative purposes. Okay, again, if it was distributed to those funds, then the patronage refund will be deemed to have been returned to the members. However, if there is still a remainder of the net surplus after the distribution, then the member has the right to receive such amount in the form of interest on share capital, but not exceeding the normal rate of return on investments and patronage refunds. Thereafter, if there is any excess, that will then be credited to the reserve fund. For the discussion on the patronage refund, you may just rewatch episode 5. Moving forward with members' rights, members have voting rights on certain matters, such as election and removal of directors, amendment of the articles or bylaws, division, merger and consolidation, ratification of certain ultra vires acts, and other matters. These voting rights are usually exercised through the General Assembly, which we will talk about more in the episode on administration. Now, in relation to the right to vote on certain matters, members also have the right to withdraw their membership from the cooperative in case they do not agree with the policy direction taken by the cooperative. For example, in case a member dissents or disagrees with the plan of the cooperative to undertake a merger, consolidation, or to amend the articles or bylaws, then Article 30 of the Code allows such dissenting member to withdraw his membership by giving a 60-day notice to the board. In fact, Article 30 allows such withdrawal of membership for any valid reason, and is actually one of the causes of termination of membership, which I will discuss later. Now, in case of withdrawal and subject to the rules and the bylaws, the withdrawing member has the right to a refund of his share capital contribution and all other interests in the cooperative. This right, however, is not available, meaning the refund will not be made if paying such refund will cause the value of the assets of the cooperative to become less than the aggregate amount of its debts and liabilities, exclusive of the members' share capital contribution. The next rights enjoyed by members should be taken in relation to some of the duties imposed by law on cooperatives. If you will recall the discussion in episode 5, cooperatives are required to keep certain books, records, and documents ready and accessible to its members during reasonable office hours at its official address. And these include the copy of the cooperative code, related laws, the articles and bylaws, register of members, books of minutes, financial statements, and others. No, you can just review this. This is in Article 52 of the code and in episode 5. Okay? In addition, cooperatives also have to publish their duly audited financial statements annually and post them in a conspicuous place in the principal office of the cooperative. Moreover, cooperatives have the duty to draw up regular reports of its programs of activities, make such reports accessible to members, and furnish copies of such reports to the members. Thus, the foregoing duties are correlative to the rights of the members to, first, examine the books, records, reports, and documents of the cooperative, of course, during reasonable hours on business days. Second, to demand in writing for a copy of the excerpts from said records without charge except the cost of production. Third, the right to have financial statements published annually and posted in a conspicuous place in the principal office of the cooperative. And fourth, to have copies of the reports furnished to them. Now, in case any director or officer of the cooperative violates the right by refusing to allow any member of the cooperative to examine and copy excerpts from the records, then the law imposes a penalty of imprisonment, a fine, and or damages. However, it will be a defense that the member has improperly used the information from records that he had previously obtained, or that the member was not acting in good faith or for a legitimate purpose in making his demand to examine the records. The last member's right for today takes place after dissolution of the cooperative. Specifically, members have the right to proportionately participate in the distribution of assets after the payment of liabilities in liquidation. And you can just review the discussion on distribution of assets in liquidation in episode 4. So, if members have rights, they also have corresponding liabilities and responsibilities. On the matter of liability, Article 29 provides that a member shall only be liable for the debts of the cooperative to the extent of his contribution to the share capital of the cooperative. which, to review, is the money paid or required to be paid by the members so that the cooperative can conduct its operations. As discussed in Episode 1, Article 29 goes hand in hand with Article 12, which provides for the limited liability principle, which means that it is the cooperative itself that will be and should be liable for debts and other liabilities that it contracted in its own name, because it has a personality separate and distinct from its members. Therefore, a member should not be held liable for liabilities that the cooperative incurred in its own name. The only thing that a member can be held liable for is his unpaid contribution to the share capital of the cooperative. And you may review the discussion on share capital in Episode 2. As for responsibilities, the law and the articles and bylaws of the cooperative can, of course, provide for the responsibilities of members. But one basic responsibility provided by the code bears discussion, namely on the matter of loans or debts taken by a member from the cooperative. Of course, the foremost duty of the member is to pay back the loan that the cooperative granted. And until such loan is paid back, then the cooperative is granted preference of claim on any debt owed by the member to the cooperative through the constitution or creation of a lien on any raw material, products, land, good, or services which the member may have acquired and held through the proceeds of the loan. Said property or interest cannot be sold or conveyed to third persons without the prior permission of the cooperative. If it is sold with permission, the cooperative's lien will continue to subsist or exist until it is fully extinguished. But if it is sold without permission of the cooperative, then the sale will be void. Now, in order to repay the debt, the member may execute an instrument in favor of the cooperative, authorizing his employer to deduct from their salary or wages, commutation of leave credits, or any other monetary benefits payable to him by the employer, and remit such amount as may be specified to satisfy the debt due from the member to the cooperative. Now, this deduction is mandatory on the part of the employer as soon as the instrument has been executed, and the deduction will continue for as long as the debt remains unpaid by the employee. Ultimately, when it comes to the debt of members to the cooperative is given a primary lien on the capital, deposits, or interest of a member for any debt due to the cooperative from such member. So we've discussed how to become a member of a cooperative, as well as some of the rights and responsibilities of members. But what if a person no longer wants to be a member of a cooperative? Article 30 of the code provides for 3 ways to terminate membership. The first method for terminating membership is by withdrawal, which I already have discussed earlier. This can be done, or withdrawal can be done, for any valid reason by giving a 60-day notice to the board of directors, and upon which the withdrawing member will be entitled to a refund of his share capital contribution and all other interests in the cooperative, except where such refund will cause the value of the assets of the cooperative to become less than the aggregate amount of its debts and liabilities, in which case the refund will no longer be given. The second cause for termination of membership is through death or insanity of the member for primary cooperatives, or insolvency or dissolution for secondary or tertiary cooperatives. Remember, insanity or death for primary cooperatives because the members are natural persons. In secondary and tertiary, the members are juridical persons, so the causes for termination in their case would either be insolvency or dissolution. Take note that in case of death of a natural person, that is a member, then his heir will be entitled to his shares, subject to the following restrictions. Namely, first, the shares held by the heir must not exceed 10% of the share capital of the cooperative, and the heir must qualify and be admitted as a member of the cooperative. Now, in case the heir fails to qualify as a member, or if his total shareholding exceeds 10% of the share capital, then the excess will revert to the cooperative, of course, upon payment to the heir of the value of such shares. Of course, the heir has to be paid because otherwise this will result in unjust enrichment, which is prohibited by law. Finally, membership in the cooperative may be terminated by a majority vote of all the members of the board of directors for any of the following causes. First, where a member has not patronized any of the services of the cooperative for an unreasonable period of time. How do we determine what is an unreasonable period of time? This may be previously determined by the board of directors. Second, when a member has continuously failed to comply with his obligations. Third, when a member has acted in violation of the bylaws and the rules of the cooperative. And fourth, for any act or omission injurious or prejudicial to the interest or welfare of the cooperative. Now, in order to terminate a member on any of those grounds, the board must inform the member of the intended termination in writing and give such member an opportunity to be heard before the board actually terminates the membership. Okay, so that's part of due process. The member may then appeal the board's decision within 30 days from receipt, either to the General Assembly or, if one was created, to the Appeal and Grievance Committee, whose decision shall be final. Now, the Assembly or the Committee, as the case may be, has 30 days to decide on the appeal, failing which, the appeal will be deemed approved in favor of the member. And of course, while the appeal is pending, the membership will remain in force. Okay, he will still be a member. So that's it for the rules on the first half of the composition of cooperatives, namely the members, which opens up the last few questions on this topic. Who directs the general policy of cooperatives, and how are the day-to-day affairs of a cooperative managed? These matters and more will be discussed in the next episode, where we will take up the rules on the General Assembly, Board of Directors, and officers of cooperatives. So I hope you may have picked up a thing or two, and I hope to see you next time. See you soon, guys. Bye!